Welcome back, everyone. In this lecture, we're going to be exploring the wide array of issues and decisions that often present themselves at the end of life. What's interesting, though, is that even though we usually see these factors come to the forefront during old age or terminal illness, these are issues that we should be looking at when we are much younger. In fact, the earlier we have these plans or documents in place, the easier it makes it on everyone involved, the patient, the healthcare team, and certainly the family as well. So when we talk about these end-of-life decisions, what kinds of things pop into your mind? Before we jump into all the medical decisions, let's first start with other basic human needs. As one ages or becomes ill or injured, we have to consider requirements for food, shelter, and housing first. Oftentimes people worry about who will help care for them as they become less independent or less able to provide for themselves. This may mean things like knowing who will assist with cooking or cleaning or other household tasks. It may mean figuring out who you can trust to help you with paying bills or other financial matters. Even determining who will be there to help you take a bath, get dressed, or complete other activities of daily living. For many people, and depending upon their culture, there may be set expectations regarding who is supposed to care for the ill or aging. Maybe it's the entire family or a specific family member. Maybe the expectation is to hire help to come into the home. Maybe there's pressure to move into an assisted living or skilled nursing facility if the family cannot or is not willing to care for the person in their home. So these questions of who is going to care for me and where am I going to live must be addressed first. We've talked about unfinished business many times already, but it's important to note that people don't have to wait until they're on their deathbed to address these different issues. Are there things that need to be done, that need to be taken care of regarding one family? Does the person have any spiritual concerns or rites or rituals that are important for them to participate in? Are there financial concerns, either regarding how to pay for current or upcoming expenses, or from the perspective of trying to leave something for others after you die? These types of factors influence what one wants or needs to do while they're still able. Autonomy is really important to most people in the United States, but it's not like that in other parts of the world, or even with other cultural groups. As one ages or their health declines, it's important that they get a chance to be involved in decisions about who will be involved in helping care for them or in making decisions. Do they want family involved? And if so, is it everyone in the family or just specific people? Or do they want to be as independent as possible and not let others have a say in what's done to care for them? There's not really a right or a wrong here, so it is important that we find out what's appropriate for our patient within his or her cultural, ethnic, religious, and social contexts. Let the patient be your guide. Finally, there seems to be this fine line that many Americans walk as they become more dependent or as death approaches. We seem to want to find this balance between receiving the help we need, but without becoming a burden on others. Even if the expectation is that our family will care for us, most people don't want to overwhelm or burn out their loved ones. And if the expectation is that one goes to a nursing home, one doesn't want to burden their family with the high costs associated with private care. Either way, this can be a stressful and difficult time for people, particularly if there haven't been any plans or discussions prior then regarding the need for immediate decisions that have to be made. In reality, these are things that we can and should be thinking about earlier in life. Even if it seems silly, as if you feel you're several years away from needing to make these types of decisions, it can still be helpful to start thinking about it and having some of those initial conversations now. Talking with your family, your spouse or partner or others can help you kind of process through the options and be thinking about what you need to do now in order to hopefully have your wishes met when the time comes in the future. For the purposes of this presentation, we're going to focus on different types of pre-planning that help us not only with family or financial matters, but healthcare matters as well. These are decisions that ultimately end up getting made by someone. Sometimes it's the patient, maybe the family or the physician, and these may be addressed before the person dies. But oftentimes these issues aren't addressed, and thus end up getting made in the midst of a crisis, or possibly even after the death has occurred. As this passage from The Last Dance suggests, by acknowledging the inevitability of death, we can begin to prepare for it. Adequate planning helps ensure that sudden, unexpected death does not add to the difficulties faced by one's survivors. When we consider these different types of pre-planning, which we'll explore in more depth in today's lecture, we're talking about a general term called advance directives. As we can see on this infographic that I found online, an advance directive is a way to tell your loved ones and doctors what your wishes are. If something were to happen and you couldn't speak for yourself, then they would already know what you would or would not want to have done. This may involve healthcare, financial decisions, or even what to do with your personal property, or possibly your children. If we think about medical care first for a moment, we can see here that 90% of Americans have heard of a living will, which is a kind of advance directive, and 71% have thought about their specific healthcare preferences. And yet, only 29% actually have some type of advance directive. Of that number, research shows that only about 7% of people have actually talked with their physician about what those advance directives are. So we can see that talking about it is at least a good start. But if we don't take the next step and actually put our wishes into writing, then how likely is it that our wishes are actually going to be carried out? As we start to consider these different ways to plan ahead, be thinking about what medical treatments that you would want or would not want done, and in what types of circumstances. Also, be cognizant of what matters most to you in times of crisis. Do you want family nearby or with you? Is it important that you be at home? Does spiritual support take precedence? What is it that you will want or need, and why? And ultimately, who will speak for you if you can't speak for yourself? Sometimes the person we know will speak up isn't necessarily the person who will actually represent our views and desires. And if that's the case, you need to be thinking about who would carry out your wishes. In this lecture, we'll look at lots of different types of advance directives, and we'll have an opportunity to complete some as our assignment for this week. To help us conceptualize and visualize this concept, let's look at a couple of different images. I think this is a nice summary. It simply states, an advance directive is a compilation of legal and medical documents that gives you control over your own health care. In other words, it's not just one thing, but rather a collection of documents that you've prepared that outline your wishes. This other image is from the Cleveland Clinic, and I like how they depict advance directives as this sort of umbrella just in case you need it. It's like any other type of preparation. We hope we don't ever need to use it, but it sure is nice to have it in place already if we do end up needing it. Just like an umbrella protects you from the rain, so do advance directives protect your rights and wishes in the event that you become incapacitated or are no longer able to make your own decisions. We don't have to put the umbrella into use if we don't need it, and advance directives are the same way. You may not ever need to use them. You may be able to make your own decisions and stay healthy enough and mentally cognizant enough to call your shots until the day you die. In that case, your advance directives might not need to be used, and you don't have to worry about other people trying to make decisions for you. But there's no guarantee. and chances of you needing someone else to know what you really want done or not done are pretty good. So it's always nice for you and for your family to be prepared. Anything can happen to any of us at any time and at any age. So it's good for others to know what our wishes are. Do any of you have advance directives in place? My husband and I did ours when we became pregnant with our first child. We wanted to be sure that we had everything in place just in case. So how does one even begin? How do you even know what to think about, what options to weigh, or what you might want or not want at the end of life? For starters, it's always a good idea to have a talk with not just your family, but also your physician. Doctors are people too, which means that they have their own preferences, values, and beliefs. You want to make sure that your primary care physician has views that are in line with yours when it comes to enforcing your end-of-life decisions. For example, if you feel strongly that you do not want to be hooked up to any life-sustaining measures, such as a mechanical ventilator or artificial nutrition, but your doctor believes in doing everything possible, then what will happen when the time comes for that decision to be made? If you don't have any documentation in place, your physician is likely to do what he or she feels is best for you, but that may not be the same as what you think is best for you. You also want to be thinking about what it means for you to be alive. Is that just a very basic physical status of having your heart beating and your lungs providing oxygen for your body? Or does that include some type of mental or intellectual capacity to think or feel? What do you think constitutes a good or bad quality of life? The ways you conceptualize and feel about these things will influence your end-of-life wishes. What does it mean to you to go from living to dying to dead? Is it just cellular or biological death? Or does brain death play a role in how you view what's living or what's dead? These are big questions with no easy answers, at least not one set of answers that's the same for everyone. If these are things that you haven't ever thought about before, now is a good time to start. It's not always easy, and it may seem very abstract at this point in your life, but it is essential nonetheless. For patients who are terminal, who may or may not be receiving palliative or hospice care, it's essential to still include them in these types of decisions. When the caregiver really gets to know the patient, we can empower them and allow them to participate in decision-making. We can work within the constraints of the situation to show our respect and try to accommodate the patient's choices. Remember, we all have our own preferences though, and much of this is dictated by our own family values, our culture, even our spiritual beliefs. Consider if you had a life-threatening illness. Would you want full disclosure of all the information? Would you want to know everything? Or do you believe that ignorance is bliss, and thus you wouldn't necessarily want all the details about your condition or prognosis? What if it was your parent that was sick? Or your sibling? Or your child? These aren't easy to think about, but again, they are important. As a healthcare provider, one should be willing and able to talk about death. It doesn't mean that the healthcare provider has to bring it up all the time or even force the issue, but rather that he or she be willing to talk about it with the patient and the patient's family if that's what the patient desires. We walk a fine line between providing information about death and what may come, with maintaining that hope or not wanting to give someone a death sentence. This can be an awkward place to find ourselves in, and so we don't have to put ourselves in that position. Rather, just be open to hearing what the patient is saying. Be aware of their concerns and do what you can to listen to them and offer support. Let the patient and family guide you, but you have to be open to it. You can't just always change the subject or avoid the topic, especially if it's right in front of you. This comes with time and experience, and you can become more comfortable working with dying patients as you have more exposure and opportunities to interact with patients and families as death approaches. As we consider these wishes, let's talk in more detail about advance directives and specific types of documents that may fall under this category. We've had a couple of different informal definitions a few minutes ago, but here is a more formal definition. An advance directive is any statement made by a competent person about choices for medical treatment should he or she become unable to make such decisions or communicate them at some time in the future. In other words, these are our wishes regarding our own health. We have a constitutional right to make our own choices, free from duress or coercion from others. These are decisions that we make in advance, and we document them in writing so that others know that they are in fact our own wishes. Another thing that's important to note is that these don't go into effect unless we are unable to make our own choices. There's a big myth that completing advance directives, such as a power of attorney, allows someone else to take over your estate and your accounts and to do whatever they want to do right away. That's false, though. That person or those people don't get decision-making powers unless or until you are no longer able to make those decisions for yourself. And this is important for people to know. So who really needs advance directives? Well, in short, we all do. You do as well. Anyone who's a legal adult in the state in which they reside. So in Nebraska, anyone 19 or older. In other states, anyone 18 or older. But why not younger people? Why might they not need advance directives? Quite simply, because unless they're emancipated through the courts, they're still a minor and their parents or legal guardians retain the right to make those types of decisions for them. Once you're an adult, you have many rights when it comes to advance directives. You have the right to elect to not complete any. You have the right to fill them out, but you don't have to give a copy to your healthcare provider. Now, it certainly may impact whether or not your wishes are followed, but there's no law requiring you to complete it and provide others with copies. Finally, if you do fill out advance directives, you always have the right to make changes or revoke those forms. Even with ourselves, my husband and I, we've changed the information about who would be our healthcare power of attorney, and we've changed our will and testament to change who would assume custody of our children if something were to ever happen to us. That's your right, and you're able to make those types of changes. It's not like you state your wishes at one time and then you're stuck with them forever. All you need are witnesses, and for some cases a notary public, and you can legally change your wishes at any time. Just remember, if you make those changes, be sure that you let people know. This means that you might want to make new copies of your documents that you can give to family or close friends, and you may need to update the physician's clinic or hospital so they can add the new forms to your electronic medical record. If you don't tell people you've made changes, they'll have no way of knowing. So make sure that you remember to take that next step and give them a copy of the updated paperwork. Why might you need advance directives, though? Most of you are quite young, anywhere from your late teens to your early to mid-60s. You don't think you're going to die soon, so why worry about these types of things? Well, as you probably all know by now, people of all ages die. We don't get to pick and choose when it's our time to go or how old we'll be when the end finally comes. So it's important that we have these conversations now, when we're still young and able to think clearly. On the screen we see 3 young women, Karen Ann Quinlan, Nancy Curzon, and Terry Schiavo. None of them, and certainly none of their families, thought that they would need advance directives as early as they did. In 1975, Karen Ann Quinlan was 21 years old. She went to a friend's birthday party where she had a few gin and tonics and took some Valium. She hadn't eaten in 2 days as part of a crash diet. Shortly after consuming the alcohol and Valium, she felt lightheaded, and her friends took her home and put her to bed. About 15 minutes later, when they came back to check on her, they discovered she was not breathing. Paramedics were called who performed CPR, and they got her heart beating again. However, Karen did not ever regain consciousness. She had suffered irreversible brain damage after having stopped breathing for 15 to 20 minutes. Doctors diagnosed her as being in a persistent vegetative state, or PVS, like we talked about early on in the semester, and she was placed on a ventilator, and an NG tube was inserted for artificial nutrition. Over the next few months, her condition gradually deteriorated, and she got down to less than 80 pounds. Her parents believed that this was an extraordinary means of prolonging her life, and they requested that the ventilator be removed. The county prosecutor, however, threatened the hospital and the doctors with murder charges if they disconnected her life support. The court then appointed a legal guardian to represent Karen since she could not voice her opinion. The Quinlan family took the case all the way to the New Jersey Supreme Court, where the court granted their appeal, saying that her parents did have a right to make this wish on her behalf. When Karen was taken off the ventilator, she surprisingly continued to breathe on her own for a while. The parents then decided to continue the artificial nutrition, and she lived for 9 more years in a persistent vegetative state until she finally died of respiratory failure in 1985, when she was 30 years old. Ultimately, the question came down to this: can the courts force doctors to go against the will of the family, even in cases that appear to be hopeless? In cases of persistent vegetative state or brain death, there is no chance of the person regaining brain activity or being able to ever think again. So is it legal to keep them alive when some argue that they are no longer really living? These are difficult questions. If we look at the middle picture now, we see Nancy Cruzan. In 1983, Nancy Cruzan was 25 years old when she suffered severe injuries as a result of a car accident. It was estimated that her brain had been deprived of oxygen for about 20 minutes, and she was left in a persistent vegetative state. She was not on a ventilator, but she did have a G-tube to deliver artificial nutrition and hydration. After nearly 2 years, and with no changes or improvement, her parents requested that the G-tube be removed and she be allowed to die a natural death. They claimed that on several prior occasions she had already indicated that she would not want to live in this kind of condition and would not want to be kept alive by artificial nutrition. The courts ruled that the testimony of her parents and friends was sufficient evidence of her wishes, and they ordered the G-tube to be removed. However, the Attorney General of that state appealed the decision, and it went to the Missouri Supreme Court, who then overturned the lower court's decision. It stated that her verbal statements to family and friends did not constitute clear and convincing evidence. They felt that preserving Nancy's life outweighed her right to refuse treatment. Her parents appealed their decision, and the case went to the U.S. Supreme Court. This became the first right to die case that the U.S. Supreme Court ever heard. The Supreme Court ruled that her parents were allowed to discontinue the artificial nutrition, and she died in December of 1990, nearly 8 years after the car accident that left her in a PVS. The court ruled that competent individuals have the right to refuse treatment, or a surrogate can make it for them if they are unable to do so. They also ruled that states can set their own laws regarding how this surrogate decision maker is appointed and what constitutes clear and convincing evidence. This decision underscored the importance of informed consent as being central to the decision-making process in healthcare. This case brought about the need for advance directives as an effort to clearly convey patients' wishes regarding their own health care in the event they are no longer able to make those decisions themselves. And finally, we see on the right-hand side, Terri Schiavo. In 1990, Terri Schiavo was 26 years old. She went into cardiac arrest at her home and was resuscitated, but suffered massive brain damage due to lack of oxygen to her brain and was left comatose. After 2.5 months without any improvement, her diagnosis was changed to that of persistent vegetative state. For the next 2 years, doctors attempted therapies such as physical therapy and speech therapy, as well as some experimental attempts to try to return her to a state of awareness, but they had no success. In 1998, 8 years later, her husband petitioned the Sixth Circuit Court of Florida to remove her feeding tube. Her parents, however, opposed, though, as they felt she was still conscious, even though doctors had determined she was in a persistent vegetative state. The court determined that Shiva would not have wished to continue life-prolonging measures, and her feeding tube was removed. However, it was reinstated several days later, and then the courts again ordered that it be removed. The parents appealed it, and it went all the way to the federal courts and then to the Supreme Court. Her feeding tube was disconnected for the final time on March 18, 2005, and she died 13 days later, which was 15 years after her initial cardiac arrest. The case spurred highly visible activism from the pro-life movement, from the Right to Die movement, and from disability rights groups. Since her death, both her husband and her parents have written books on their side of the case. These are heart-wrenching, complicated cases, but they didn't have to be. They paved the way for our current understanding of healthcare rights, and they reinforce the importance of having people document their wishes were something tragic to happen. And with all these women, they were so young, just in their 20s at the time of their persistent vegetative state, and it illustrates that advance directives are for all adults, not just the elderly or terminally ill. These cases also pave the way for some key legislation that guides our actions today. Here we see a summary of some of the more prominent acts to come from these cases. We can see that they go all the way from the federal level down to our specific organizations and hospitals or other facilities in which patients receive care. The Uniform Rights of the Terminally Ill Act of 1989 has been passed by many states. The law allows for a person to declare a living will, specifying that, if the situation arises, he or she does not wish to be kept alive through life support if they are terminally ill or in a coma. The patient may also obtain a healthcare power of attorney. This power of attorney appoints an agent to make medical decisions for the patient in case the patient becomes incompetent. Many people make use of this act because they do not wish to endure any pain or suffering if weakened by a fatal disease. They want to die with dignity so that family members will not have to go through emotional pain of watching their loved ones sleep through many years of life with no response to any stimuli. The Patient Self-Determination Act requires that facilities receiving federal aid must do the following. They must inform patients on their right to make decisions concerning their medical care, like their right to die. They must provide assistance in preparing advance directives. They must document advance directives in the patient record. They must provide written statements to implement the patient's request. They must affirm no discrimination because of the advance directives put in place. And they have to educate their staff on legal issues regarding medical care. The Healthcare Power of Attorney Act took this a step further and allowed states to specify what information needed to be included in a power of attorney document. You can look up Nebraska or Iowa or whatever state you live in and find out exactly what needs to be included in the state in which you reside. JCAHO and other accrediting bodies help to monitor and ensure that facilities are following the laws. And hospital policies, as well as those of nursing homes or other care facilities, outline their expectations for following advance directives. Let's take a break for now, and when we come back, we're going to spend some time looking at the details or the specifics of different types of advance directives, what they mean, what's involved, and how they impact our care at the end of life.